All right, you ready for this? We're going to do this really intensive Cram course. So it's basically the whole textbook in 4 hours, but we're going to do half of it in 2. So let's get started. We're going to go through chapter 1. We're going to hit everything in the book, no PowerPoints. It's literally just going to be a Cram sheet put on the board. So this is how we're going to do this. So first chapter is becoming a real estate broker. I'll be looking down the book a lot so I can kind of get an idea. Okay, so first thing we talk about is the application process and what we need to have. And one thing that's always tested is social security number. What is the social security number for? It's to check child support, right? Remember that? Mm-hmm. This is the one question you'll be asked. Okay, so that's the first thing that will come up. We're going to go through. You have to do the fingerprint process, the criminal background check. We don't really need to cover. There's this thing called the summary of applicants. You remember what the summary of applicants is? Summary of applicants is when you have something come up on your background that needs more information, and a lot of times you have to appeal to fracking sit in front of the committee. It's 90 days for your application. So 30 days for a normal process to get your application approved. Up to 90 days. FRAC meets in Orlando once a quarter. So this is a summary of applicants, and it's to check for licensing. It's licensing, approval, 90 days. 90 days at that point. Summary applicants, they get 90 days. We have reciprocity. Florida doesn't have reciprocity in any states, but Florida has reciprocity if you're an armed service member and your spouse. Do you remember that? Mm-hmm. Okay. We're going to move on from there. Non-resident application. What's the definition of a resident? A Florida resident?
4 months.
4 months continuous and or intention to live 4 months. So if you moved here and you've only been here a day, you're still a resident if you're intending to live here permanently.
So like if you signed a 6 or 7 month lease,
you're a resident.
You're a resident. Okay.
Yeah. Mutual recognition is when another state recognizes your license or we recognize another state's license. I believe there's like 7 right now. You have to take a what?
A state exam.
40 question state exam, right? Law exam, only law exam. Because the assumption is we recognize your license, you understand the principles of real estate. All right, so let's see what else there is in chapter 1. Education requirements. So there's 2 types of education requirements. You have a real estate graduate, and then you have a member of the bar, so an attorney. So an attorney has to do, let's do the easier one first. A 4-year graduate of real estate has to do what?
They're covered throughout the whole thing, so they got
except for CE.
Except for CE,
right.
Yeah.
Lawyer needs FREC 2
and post.
Because they only FREC 2 is talking about managing a brokerage, what we're doing right now, right? FREC 1 is the basics of real estate, which is covered in a normal law curriculum, right? Continuing education, the lawyer does that through their own continuing education.
Right, so they don't have to submit.
Right.
Yeah.
So they only need post-licensing for the broker course and the broker course itself. We renew our license every 2 years. The first cycle is 18 to 24 months. It always renews March 31st or September 30th. The first cycle, you have to do 45 hours post-licensing, and it has to be done prior to that expiration, that first expiration, which is between 18 and 24 months. If you miss it, you lose your license, you have to start all over. Okay. If you miss broker post-licensing or the equivalent, GRE 2 and 3, then you can
to the 14.
Continue to do your other class or no? No, you can't. You lose your license. If you don't do your post-license, you lose your license completely and you have to go back and start all over as a sales licensee. You don't want to do that, so get your CE done and you're good. There's 3 types of status for your real estate license, right? You have active, which is I'm active and selling. You have voluntarily inactive and you have involuntarily inactive. Voluntarily inactive means I keep my education up, I do everything I'm supposed to do, and I just am working at a job that maybe doesn't allow me to have my license, so I keep it inactive. It's voluntary. You've chosen to keep it that way. Involuntarily inactive is for a multitude of reasons. You've got some type of fine, you had a disbursement from the real estate recovery fund, and you weren't able to pay it back right away. You didn't complete your continuing education, something that you're not in control of, that the state's telling you can't have your license active.
So less than 12 months, 14 hours, more than 12 months, 28 hours.
Correct.
Okay.
Right. The other piece of this is, can we reinstate a null and void license? We can in some hardship situations, but don't get to that point, right? All right, license and revocation. Suspension and revocation. Revoke means what? Revoke means you lost your license. Suspended means what? You can't practice until some obligation is taken care of, i.e. paying back the real estate recovery fund. The other piece of this revocation is revocation without prejudice. What is revocation without prejudice? Revocation without prejudice means I'm not going to give you the license because you didn't take the class. So for example, you're taking a real estate course and they issue you a nursing license. They give you a nursing license on accident. They're going to revoke that and not take penalty against you because it wasn't your fault, it was their fault. So some type of administrative error. So if you hear that revocation without prejudice on test, that's what it is. Let's see here. So registration. So registration is a process of submitting the information into the DBPR, right? Licensing is what they're giving you.
Unlicensed activity, 3Fs.
So yeah, so that was the next thing. So 3F. So what is the fine for unlicensed activity? Felony, $5,000, 5 years in jail. And it's not required that they give you that, but it's up to those penalties. So FFF. The other one is 111, which is rental lists that are outdated for a fee. What my point on that is just don't do it. Just give them a rental list. You don't have to worry about it. So it's 111, right? $1,000 fine, 1 year, and it's a first-degree misdemeanor. Okay. What's the difference between a group license and a multiple license? A lot more information. Group license, multiple license. And I'm not going to write all the definitions on the board. These are just the topics that are going to show up on the exam, right? Group license is what? It's like your builder that has a bunch of different sites. Multiple license is like your brokerage that has multiple offices, branch offices. We call that multiple license. Or maybe I own a referral company and I own a secondary brokerage and I have 3 different licenses. That's what multiple licenses is. Right, brokers can have multiple licenses. True or false? True. Answer's true. You have to change your business address if you move your location within 10 business days. If you don't, it's $500 administrative fine. They call it citation here, I think. What are the functions of a real estate agent? What do we do as real estate agent? What is the acronym? What are our functions as a real estate agent? You remember the A-bar sale?
Yeah.
So advertising, buying, appraising, renting, selling, auctioning, leasing, and exchanging property, right? So that's the A-bar sale. What I usually see on the exam is missing the A, and it's just bar sale, right? Advertising is a broker activity. When you talk about getting compensated on a real estate transaction, you get compensated. Commission means you have to, or transactionally means you have to have a license. That's very simple. the thing you have to think about is it doesn't matter if you actually got paid to be committing a crime or be committing some type of bad thing, right? So here's the thing. If somebody offers or you accept or you continue to do the job because somebody performed something, you're trying to help somebody. If somebody's telling you they'll give you a bonus even though you're not licensed and you continue to work there, that can be construed as not abiding by the law. So just be careful. Just because you don't commit the act doesn't mean you can't get in trouble for the act. Do you remember the builder thing where the guy was a developer and his son worked for him, he didn't have a license, and he couldn't sell enough houses, so he's paid hourly, but since he couldn't sell enough houses, he's like, well, every fifth house I'll pay you $500. Even though that never happened, they're still both guilty. Not just the seller, not just the buyer, or not just the dad, but both the son and the dad. There's 5 different areas of real estate that we sell, right? We sell residential, commercial, industrial, agricultural, and business brokers, right? So why is a business broker? Why do we have to have a license to be a business broker? Because most businesses have some type of real property attached. You remember all that? Mm-hmm. There is exemptions to the real estate license, right? So what are the exemptions? Well, you can sell your own house for yourself, right? If you are a partner in a firm and you're only getting a pro rata share of the equity, then you don't have to have a license, right? If you are selling cemetery lots, you don't have to have a license, right? If you're working for a government agency who performs these activities, you don't have to have a license. If you're doing real estate stuff within the scope of your other business, you don't have to have, you're not getting commission. So if you're a closer closing a real estate transaction, or if you're a CPA handling taxes for somebody, that's fine. You just can't actually physically be the one selling it. If you rent mobile home lots in a mobile home park, you don't have a license. Right? There's a bunch more, but those are pretty much, just understand the concept is scope of work, right? Whatever your scope of work is, equals if you have to have a license or not. I'll put scope of work up here. Okay, so scope of work. That's it for chapter 1. Questions on that? All right, questions. We're going to skip on to 2, opening a real estate office. We're going to talk about business structures. This is most likely going to be a negative question. What can and can't register as a real estate company, right? So you have things that can register: corporations in general, limited partnerships, limited liability corporations, limited liability partnerships, and sole proprietorships. Where you're going to get tricked on this is where somebody says, can you register a corporation sole as a real estate company? No, you cannot, right? These are the things that cannot be registered as a real estate brokerage. The 2 that we normally see is corporation sole and joint ventures. Why not a joint venture? Well, a joint venture is something you do once and then it's dissolved, right? A corporation sole is a church, and then business trusts, cooperative associations, and unincorporated associations. Those things cannot be real estate brokerages. And there's obvious reasons, right? Churches are mostly non-for-profit, and it doesn't matter, you can be a for-profit or non-for-profit, but they don't pay taxes. They have a totally different structure than anything else as far as business is concerned. Joint ventures get dissolved. Trust, a lot of times that's investment type deal, right? Cooperative associations will be what we call co-ops, right? So co-ops are a building where they sell stock and have a proprietary lease and people live there, right? So they're not a real estate brokerage, there's residents there. Unincorporated associations would be the same thing. It's like an HOA. We're not real estate brokerages. Make sense? Mm-hmm. All the other ones make sense as being real estate brokerages. There's the general partnership is 2 or more people. Each general partner has to be a real estate broker, right? We talked about that. All people are liable. So the difference between general partnership and limited partnership is this. General partners, everybody involved is 100% liable for the company. Limited partnership means what? Means that I'm only limited to what my investment is. So if I gave the building, that's all I'm limited to. If I gave $20,000 up front, that's all I'm limited to, right? That's basically partnerships in a nutshell. Anybody who's dealing with the public is presumed to be functioning as a real estate broker, needs to have a license in these partnership situations. We have trade names. Before we get onto that piece, we have this thing called ostensible relationships. Ostensible relationship is what? Do you remember what ostensible relationship is?
Yeah, if you and I were both in the same office,
Right.
they thought that, yeah, we were
So
working together.
Right, so it's the presumption of the public saying that you're partners, right? Whether you're a partner or not, if they presume that, then you could be liable. So we need to make sure that we have separate entrance doors, right signage, etc. Otherwise, we may or may not be accused of an ostensible partnership. Let's see, for-profit, non-profit corporations. Corporation is what? It's a fictitious person. You can file subchapter S. This for tax filing purposes. If you do, you can only have 100 stockholders. You can have no more than 100 stockholders in the subchapter S, right? And we're just hitting the high points of this, but if something happens and the broker, say, passes away or gets in a car accident, is incapacitated, what do? We have this thing called a vacancy in office. What is a vacancy of office?
Anyone below that cannot practice real estate.
Right, so what do? We fill it, we have a temporary broker put in, how quickly?
Within 10 days?
I think it's 14 days.
Okay.
It's 14 days, right? If it's not done in 14 days, everybody's license gets involuntarily inactive, right? So then the temporary broker can be placed for 60 days. At the end of 60 days, we have to have a permanent broker in place. Talk about corporation sole. We already talked about that in joint ventures, business trusts. Ostensibles there. Registering a trade name. So we're going to register a trade name under a fictitious name. We're going to go on the Secretary of State website or Sunbiz in Florida, right? And we're gonna create our fictitious name. We're gonna register that fictitious name. We're gonna file a registration with the Department of Business and Professional Regulation, and then they're gonna approve it and give that corporation, that fictitious company, a license. That's how that works. As a real estate associate, true or false, can you put your business in a fictitious name? No, the answer is no, it's false. You can only be a fictitious company if you're a real estate broker. We're going to talk about out-of-state brokers' offices. So you don't have to be a domestic corporation. Domestic corporation means that you are in the state of Florida, operating in the state of Florida. Your office is in the state of Florida. Or you could be a foreign corporation, which means you're outside the state of Florida. If you are outside the state of Florida, you have to give permission for the DBPR to be able to look at your stuff outside of Florida. Right? Branch office registrations are not transferable. If you close a branch office and you move it to a different location, you can't register that. Real estate broker may reopen a branch office at the same location during a license period, requesting a reissue of branch office license. Okay, these are branch offices. Your corporate office has the address change. Does that make sense? If you have multiple offices, this is what we're talking about. We can't close over here and open up the other side. Temporary shelters. So you see these mobile homes. I call them mobile homes. The trailers outside these construction zones. If they're not conducting real estate transactions, it doesn't have to be registered. If they are, then it does have to be registered. And when you register an office, you have to have 3 things on the sign. What are the 3 things that have to be on the sign?
Name of brokerage.
Name of brokerage.
Licensed real estate.
Licensed real estate broker and broker's name. Alright, so name.
Trade name or office
broker,
name.
And LIC, real estate broker, or licensed real estate broker, right?
Mm-hmm.
Can you have any other abbreviations?
No, either spelled out licensed or LIC period.
That's it. And the name, the font has to be similar size so that people can understand that. If you have sales associates and you put them on the sign, what do you have to do? You have to separate them, right? You have to separate them. Or if you have a broker associate that you want to put on the sign, you have to separate them. You have to put a line through there, line under it, so that people understand what they're looking at. For ADA compliance, you also have to have what? You have to have access, you have to have elevators, you have to have restrooms, you have to have anything else, and you have to have how many parking spaces per 25?
One.
One. Okay, so that's pretty much what you know there. So for ADA compliance, we have team advertising. So if there's team advertising, we have to have one designated person on a team, right? It's a lot in this chapter. Team advertising. So team advertising, one designated person on the team. And we need that designated person to be checked, and we have to keep a registration of who else is on the team. We also have to not use certain words, right? We have to use we can't use like associates or properties or broker or company or anything like this. Why? Because that's going to give the presumption that you're a real estate business, you're a real estate company, and you're not. So you're acting as a broker again. Team associates do not have to have a broker's license. So we need to make sure that's separate. What is a blind advertisement? I'll put that here.
Misleads, I don't remember.
Blind is missing your phone number. It's missing something off of there, right? That you're not missing a name, missing something off of there, right? Advertising has to be real estate reasonably assumed that if I put this ad out there, that I'm a real estate agent, right? So if I say call John Smith at a number, but I don't associate with a real estate company, that's also a blind ad, right? You don't have enough information on there. You have to have at least your last name, right? You have to advertise in at least your last name, right? False advertising is putting misleading information out there. Pretty much you know that. If you're on the internet, you have to have the point of contact information immediately adjacent to the ads, right? Or on, I put it on every web page, but immediately adjacent. If you list your house for sale by owner, you need to disclose that you're a real estate licensee, because we have a one-up because we're licensed. We understand the market, we understand the business before longer, right? There's two things to know about rental list. What do you need to know about rental list besides that it's a misdemeanor? Rental list. If you give accurate information and they are unable to obtain a rental within 30 days, they're entitled to how much refund? 75%. If there's anything that's inaccurate on there, what are they entitled to? 100%, right? And what are you liable for? You could be liable for the 111, which is $1,000 fine, a year in prison, and a first-degree misdemeanor. For the lousy $100 or the $25 that you're probably gonna have to refund anyway, it's just not worth it. Just give it to them. Let them do their thing. Give them a list and say, good luck. Hopefully you find something. If you need to see something, let me know. I'll help you find a place. Get paid for the referral versus getting paid for the list. Housing for older people. So, we didn't really go over the Fair Housing Act yet, but we talk about protective classes and we talk about familial status. We can't talk about familial status with people. So when these people are writing letters to the buyers are writing letters to the seller, they are in effect violating the Fair Housing Act because they're telling somebody their story, right? So we have to be careful with that as agents when somebody presents us with a letter. What is the guideline for housing for elderly people? 80% of the units of the neighborhood, like a Del Webb, has to have 55 or older, one or more persons 55 age or older that lives there. The way they get away with it is because 20% can be under that age, and normally it starts at 45, right? All units, if a home is like a nursing home or a care facility, has every unit older than 62, then they can discriminate against the younger people. That's the only rules with familial status that we can have a protected class, or like protected class. So if you don't have the fair housing poster, you're automatically assumed to be violating fair housing. Talk about Telecommuter Protection Act, right? So what are the main things for telecommuters? What's do not call? So DNC, I'm just gonna write DNC on here. The main things are, there's three things, right? You have early to late, 8 a.m. to 9 p.m. You cannot call before 8, you cannot call after 9 p.m. In Florida, you can call for sale by owners, but federal law says you can't call for sale by owners. So what does that mean? We have to abide by the federal law, right? Now, if they're not on do not call list, you can call them, no problem. We have to maintain a registry as a brokerage that we've actually downloaded a list, and it can't be some outdated list from 3 years ago. It has to be a current list, right? There is exceptions to the do not call list, right? What are the exceptions? If I've previously done business with them, how long do I have?
3 months?
You have 18 months.
Okay.
You have 18 months. If somebody has an inquiry, has made an inquiry, how long do you have?
Oh, that's the 3 months. I
Yeah,
mixed it.
right.
Sorry. Okay.
Right. So licensee may contact up to 18 months after a business transaction is concluded. Licensee can call 3 months after an inquiry. So if I had a lead come in November 15th and today's February 8th, I can make that call because it's only been 3 months. It hasn't quite been 3 months yet, right? After 3 months, I can get a fine. In Florida, it's $10,000. Federal is $16,000 per violation. Don't do it. Email solicitations have to have opt-out, right? If it's an individual email with somebody that's different than a spamming email, right? You don't want to send out spam emails. Senders have 10 days. We then have 10 days to update our list if they want to opt out. Same thing with fax. The fax has to have the date and time, right? Emails have to have that too, right? Physical address, we have to provide a clear way to opt out. You have to know who's to and from, so you can't use these do not reply emails, right? Same thing with the fax, date and time, registered name of the company, phone number of the company, address that's sending it. That's pretty much it for chapter 2. It's not bad. Owning and managing a real estate office is chapter 3. So chapter 3 talks about fees. First thing we talk about is fees, right? Fees are, what are your initial startup costs? Are you renting a place? Are you buying a place? Do you need an attorney or an accountant to set up all your legal stuff, right? Do you need office supplies, office equipment? How many people are going to be there? How much furniture you need? All these things have to look into, right? Do you need internet? Are you going to offer signs and lockboxes to your associates, or are they going to buy their own? Joining the board of realtors, ultimately the broker's responsible for all the members. If they don't join the board, we have to pay, right? You don't want to do that. Office supplies, promotional materials, forms, right? All these things are costs that are involved in a real estate brokerage. So what the key word about brokers is that the key word under broker is broke. And if real estate agents want to be brokers, they need to consider all this stuff, or they could become broke very quickly. You have to babysit and make sure that people are paying their dues and doing their continuing education, making sure that they're not operating without a license. There's all these things that have to happen. So it's basically managing a bunch of people. So if you don't want to manage a bunch of people, don't become a broker. Or you can be a broker associate, just don't become a broker, right? Have a business plan. How many sales am I going to have to make just to break even? How many sales am I going to have to make $100,000 a year? Whatever the case is, you need to have a couple different plans and know exactly how you're going to get from one to another. Just saying I need to sell 50 houses to make 100 grand isn't enough, because how am I going to sell the 50 houses? Am I going to break it down by agent? And am I going to have training? Am I going to have call sessions? Whatever the case is, right? We have to have some type of plan to make it happen. Who are we selling to? What are the opportunities? What are the challenges? How are we going to get there? Right? Makes sense?
Fun stuff, yeah.
Yeah, all the fun stuff, right? I'm going to talk about mission statements. So income projections, income sources. I like to have a goal and then have a stretch goal, right? So my goal is this, which is some measurable. It's like a SMART goal. It's a specific, measurable, right? It's attainable, right? These are important. Whereas the stretch goal might be, okay, well, if I do this and I want to hit 15% higher, so I just multiply everything by 15% higher and then add it, right? What are the fees? How much are your taxes going to be? Are you going to rent insurance? Are you going to rent furniture? All these things are matter, right? Are you going to get a blanket E&O policy to cover 25 agents or 100 agents? Are we going to charge an E&O fee transactionally? Are we going to charge an E&O fee annually? These are all these things you need to think about, right? Then we have to decide, are we going to be a franchise or are we going to be independent? Well, there's pluses and minuses to both. Franchises come with fees, so obviously that's a negative, right? But franchises come with a nice platform for internet, for example, a nice platform for doing business. So there's both, right? Franchises have built-in networks for referrals. They have national recognition, right? We're talking about the big boys, right? Whereas an independent is what I like to call a mom and pop shop. We usually have lower overhead. We have more freedom to do things we want as long as it's in compliance. We are local and we have lower startup fees, so we can start up with a very small office and have agents get better splits and try to retain them through splits versus trying to retain them through brand recognition, right? So there's pluses and minuses on both sides. I've worked on both sides. I see pluses and minuses on both sides. Usually the national companies have better training and stuff like that. Then we got to talk about how we're going to keep our books. Are we going to log the commission at the time we write the contract, which I think is horrible because deals fall through all the time, or are we going to log the commission at the time of closing, at the time of actually receiving the check? Well, actually receiving the money and logging the money, then it's called cash basis accounting. Logging it at the time of transaction is called accrual based accounting, right? So accruing it for going forward. Now there's pluses and minuses to that too, because it may fall in a different tax year and you may have a tax advantage for that, right? Do we need additional personnel? Do we need office managers? Do we need support staff? Do we need people that will go out and do pictures and virtual tours? Do we need all that, or are we going to outsource that? Are we going to hire part-time associates, because part-time associates are going to need more help. They're going to need more of your time and they're going to do less transactions. So is that the best way for you to handle your business? Or do you want full-time people, develop them, let them go out on their own and have them do it? What I'm going to say about part-time associates, no such thing as a part-time real estate agent. You're either in or you're out. You may have another job, but you're still in. You still have to work. You still have to do everything. So you can say you're part-time, but you're not going to work part-time.
Right. And you pay the same amount as a full-time. I mean, the dues.
Exactly.
Yeah,
exactly.
the dues are the same whether, yeah.
So then we say, are we going to hire an assistant? Are we going to hire a licensed assistant? Or are we going to hire an unlicensed assistant? If we hire a licensed assistant, and agents can do this as well as brokers, if we hire a licensed assistant, we can pay them transactionally, we can pay them salary plus bonus, we can pay them a commission, we can do whatever. If we have an unlicensed associate, we have to pay them hourly. Now the difference is, and there's no bonus, there's no transactional pay, right, for an hourly unlicensed assistant. Unlicensed assistants can be paid either by the broker or by the sales associate, but anything that's transactional pay has to be paid by the broker. Unlicensed agents can do all those, I call them secretarial, ministerial duties, right? They can't do transactional stuff like writing contracts and showing houses. They can do an open house, but they're not supposed to open the door, and all they can do is give out an MLS flyer. They can't, and take names. They can't give any opinions about the house, so it's kind of a gray area. You might get in trouble. Just be careful with that, right? How are we going to recruit? Are we going to set out an advertising campaign on the internet, or are we going to do it organically? These are all things that you have to think about when you're opening a brokerage. What type of personalities am I hiring, and is it compatible with our culture? All these things make a difference, right? Are we going to make, is it going to help us benefit, have a mutually, I like to call it symbiosis, right? You have a mutual beneficial relationship. Okay, and you're going to have a contractor agreement, you're going to have a office policies and procedures, you're going to keep an HR file on all of these people. All these things are going to happen, just like if you were running a grocery store or an office, whatever the case is. It's going to be the same as running a real estate brokerage. The only thing is we have to make sure that we're not getting out of line with the real estate commission, right? So we also can do these things like non-competes and all this, but all this stuff gets into the legal piece of it. They're not really going to ask that. Just understand that if it makes sense as an office, that's how we need to look at it. Is it going to make sense? The one thing, I know we didn't talk about antitrust policies. So what is antitrust? You know what antitrust is? Antitrust is, I can't remember, Sherman. Antitrust means I'm not going to collude to have higher commissions and divvy up the area, or say everybody's going to charge 6% and we're all going to agree to charge 6%. No, we can't do that, right? We can't do that. If somebody wants to charge 10%, somebody wants to charge 3%, that's their choice, right? You can't sit there and say, well, if you take the west side and I take the east side and I refuse anybody else, and we're going to divvy this up and we're all going to agree to pay 8%, well, that's violation of law, right? You can't do that, right? It's price fixing. Don't talk about it. Don't deal with it. That's pretty much it in this chapter. What I would say as a broker, just to top that off, is have independent contractors. Independent contractors are 1099. You're not collecting taxes. You're not dealing with all the other IRS stuff, right? That becomes a little bit hard to deal with if you have multiple agents. If you have 4 or 5 agents, no big deal. If you have 25, 30, 50 agents, 100 agents, it's going to be impossible for you to keep up with that. I think that's pretty much it in there. The term company dollar, do you understand the term company dollar? Company dollar has to do with how much is the agent bringing in, right? Aggregate gross commission income would be the agent's total income coming in. So if we had a $200,000 house at 3%, that would be $6,000 AGCI, and let's say they're on an 80-20 split, they would bring in $1,200 in company dollar. That's how they would figure it out. So that term company dollar is whatever the brokerage split is. Maybe there's a transaction fee on top of that, so they get the $1,200 plus the $200 transaction fee, so there's $1,400 in company dollar. That's how it works. Chapter 4 is about escrow management. So before we flip through all the pages, we can have sales escrow accounts, and we have property management accounts, and we can have a combined account for sales and property management. So we can commingle how much in funds in a sales operating escrow account?
It's up to 5.
Sales.
Oh.
Sales is $1,000. Prop management is $5,000. Combined is $1,000 of commingled funds. Commingling means you can mix those funds in the account, right? So escrow account, you can commingle up to $1,000 of personal funds in an escrow account if it's a sales account or a combined account for fees for banking, etc., overdrafts, etc., right? Hopefully you're not overdrafting your escrow account, you'd be in trouble because you shouldn't be using that money. If you're using that money for something else like paying your bills, then that's called conversion. Conversion equals stealing, commingling equals mixing. Think about mingle. What do you do when you mingle? You mingle, you move around, you talk to people, you're mixing, right? Conversion means I'm taking something and making it something else, right? Conversion is illegal. Commingling is okay as long as it's within the guidelines established by the Real Estate Commission. Property management is $5,000. Why? Because you may have to upfront some repairs or something. You might need a little extra money. $1,000 might not cover it.
I think I mixed those. So commingling is legal, but illegal practice of commingling is intermingling, and that's the term that's actually, you're not allowed to do it.
Right. So if you're commingling $6,000 in a property management account, that's illegal, right? But here's the thing, with an escrow account, you're reconciling it every 30 days. You're signing off on it as a broker. If there's any overage or underage, you're explaining that and you're withdrawing that right away. That's how that happens. That's how it works. So for this reason, because escrow management requires extra paperwork, about half the independent brokers don't have an escrow account. Right? Some states require it. Florida does not require you to have an escrow account. Kentucky does. The broker can be a signer on the escrow account. They can also designate a bookkeeper to be a signer on the account. But no matter what, the broker has to sign off on the reconciliation.
No matter who conducts it, so your accountant might do it, but you still have
You
to.
still have to sign on, review it, and sign off on it, because ultimately it's your responsibility, right? So then we talk about how long we have when we receive a earnest money deposit binder or good faith deposit. All those three terms are interchangeable. What can we do with that? How long do we have to have it? How long can we hold it legally? Sales associates can hold a binder check for 1 business day. It has to be deposited to the broker at the end of the first business day that they receive it. Now remember, if you receive it on Friday, Friday is day 0. Monday would be day 1. Weekends are excluded. Holidays are excluded. Federal holidays are excluded. Right? So first business day, 1 day, sales associate, deposit. And the broker has to deposit it into the escrow account by the end of the 3rd business day, inclusive of that 1 business day. So if you receive it on Friday, Monday would be day 1, Tuesday, Wednesday would be day 3. Good? So if they said Thursday, or they say we got a check on Wednesday, November 24th, and Thursday's Thanksgiving, day 1 would be Friday, day 2, 3, Tuesday, Monday, Tuesday. Does that
So
make sense?
if I received a check on Tuesday, that's day 0. So Wednesday, I have to have it to you, right?
Right.
Then you have Wednesday, Thursday, you have to deposit it by
Friday. Unless, there's always an exception, right? Unless the seller allows you to have a post-dated check, which what has to happen with a post-dated check, the buyer and seller has to sign off on it, everybody has to agree that it's okay to do this, seller signs off, and then you can have a post-dated check. The other way you can do it is based on the contract, right? So it's from the date of receipt. So if the contract says binder to be received within 5 business days of the contract being accepted, now we can start that clock at day 5. day 5 will be 0,
Mm.
right? And then 1, 2, 3.
Okay.
So it's a way to, if somebody didn't get paid they were getting paid on a 2-week cycle or something, you
Right.
could push it to where it would work, right? Because nobody really wants to deal with the post-dated check, right? The other thing is what are we going to do with the interest? You can have an interest-bearing escrow account, but what do we have to do? We have to get signed off by the buyer seller. Who's getting it and how much are they getting, right? My advice is don't worry about the pennies if you're a small broker, because you're only going to have maybe $50,000 on an escrow account in a good month. If you're a big broker, you might have $3 million or $4 million that you're drawing interest on, so it might make sense to do it. But remember, you have to get agreement by all parties to let you have the interest if you're going to do that. Retention of business records. How long do we have to keep records?
5.
5 years under statute of limitations, unless, it's always an unless. My favorite term in the real estate business is to say it depends, right? Because it always depends, right? So if you're under a lawsuit, because you have 5 years to open that lawsuit, so if somebody opens a lawsuit on year 4, 11, and 30 days, then you have to hold it for an additional 2 years, so I would say up to 7 years if you're under litigation. You can do everything digital, that's perfectly fine nowadays. And if it's a peril contract, which means oral, it's 4 years, right? 4 years for a peril contract. Anything that's written. The problem with peril is it's most of the time unenforceable, right? Unless you can prove that there's a pattern. If you're paying a referral, if you're referring business to somebody and they're paying your referral and they decide not to pay your referral on one transaction, you can go after them under a peril contract because you can show that it's happened, right? If you have this at face value, this prima facie evidence that you can do that, right? Just like if you had a real estate license. If you have a real estate license, you're presumed to be active, you're presumed to be able to practice, right? That term is prima facie. Talk about monthly reconciliation. We talked about how much can be in there. Talked about that. Disciplinary guidelines. You can get a $500 citation if you're not maintaining your escrow account. What happens if you have conflicting demands? That's the next thing. We have this acronym. This acronym is MALE. This is conflicting demands. So what are these terms? What is this? Conflicting demands. Conflicting demands means we have a cancellation of contract and we have the seller arguing with the buyer over who gets the earnest money deposit or the good faith deposit or binder or whatever you want to call it, right? What do? Well, first of all, as a broker, if we're going to litigate, we have to know if we're taking part claim to it or not, right? If we're taking part claim to it, then we have a declaratory judgment. If we're taking part claim to it, we have a declaratory judgment. If we are not taking claim to it, then we file this interpleader, right? This interpleader court procedure. That's litigation, right? But we don't want to go to litigation first. We want to go to mediation, right? Mediation is the easiest. Mediation is like you sit around a table with a third party or non-third party, it doesn't matter. You can talk amongst yourself to see if you can do that. Now, if you hire a third party to make the decision for you, then that's called an arbitrator. It's called arbitration. It's more expensive. Typically, it will eat up the binder and you won't get anything back anyway.
So mediation is more of us.
It's informal.
The sales associate, the broker, we're handling it through via text message,
Right.
Emails, whatever.
So we did a mediation where we sat around a round table and there was a third party involved, but it wasn't arbitration. It was a third party, the title agent, sitting in with us. We're all talking amongst each other, buyer, seller, lender, sales associates, everybody's together and we talk it through mediation and we come up to an agreement. That's all that matters, right? If you are in arbitration, it could be anybody and the person that is the arbitrator could be licensed or non-licensed and they make the decision based on the facts given. So if they like somebody better than somebody else, they could make the decision just solely based on that. You have to make sure that you're not in that situation. Arbitration is binding. If you see the word binding, put it with arbitration. If you see it with a question. Litigation is court procedure. Right, we're not going to jury trial over a binder dispute, but we will talk about it. Interpleader says if the broker does not have financial claim to the disputed escrow funds, then that gets deposited into the court registry, and you file this court proceeding called an interpleader, and it goes to whoever they rule on. Declaratory judgment means I put out expenses, I want some of the money back to reimburse myself for the costs that I had. If you're a real estate broker and you have an escrow account, not lawyer with an escrow account, real estate broker with an escrow account, we can file for an escrow disbursement order. So mediation, arbitration, litigation, escrow disbursement order, EDO, and we can do it through the real estate commission. Only if it's held by a broker escrow account. And then what we do in that case is we submit it over to FREC. We have to notify FREC within 15 days if we have good faith doubt that the parties can work it out. We have to start the procedure within 30 days, and these are business days, right? 30 days to actually start the procedures. And if for some reason they decide that they're going to work it out, we have to notify FREC within 10 days that they worked it out and we no longer need the EDO, right? We don't want to waste the real estate commission's time if we worked it out, right? We don't want them reviewing something, wasting their time when they could be working on something more serious. So that question can be tough because there's 15 days to notify of the good faith doubt. There's 30 days to start the procedure, and then there's 10 days to cancel the procedure if somebody decides to agree, which doesn't happen that often, but it does happen on occasion. There's some exceptions to escrow disbursement order. If you have a condominium and you didn't get the condo docs, including the frequently asked questions, within the 3 days or the 15 days, depending on if it's new or existing, we now can disperse those escrow funds to the buyer without a signed cancellation. Also, if the mortgage is denied within the financing contingency period, as a broker, we can disperse without a cancellation. Now, most real estate brokers aren't going to do that because they want to have something signed in writing. But legally speaking, the real estate commission rules say that we can, right? HUD-owned property, well, that's government stuff. There's always exceptions for that as well, right? So it says here, HUD-owned property are exempted from notice of settlement procedures under Chapter 475, which is real estate commission laws, right? The broker is required to follow HUD's agreement to abide and broker participation requirements. So however HUD spells it out, we have to abide by their rules, right? It's Housing and Urban Development supersedes the state real estate commission, right? But see, the two things that came up here on page 120 is condominiums and financing contingency, and we can disperse that, but most people won't, right? Because they want to have something to cover themselves. Because why? If they get sued, if I disperse to the buyer and the seller sues me, what happens? I have to submit a request for the real estate recovery fund to cover that. If I'm found at fault, then my license is going to get suspended and I have to pay it back, right? If I'm found in the good, then it's good, right? If I follow the disbursement order and I get sued, and the plaintiff wins over me, they have to try to seek judgment for me, and then they send a request to real estate recovery fund. As long as the escrow disbursement order, I can apply to the escrow disbursement order, then I don't have to worry about license suspension. So there's all these things that you want to make sure you're okay with. Now, real estate recovery fund has a fee involved, right? When it drops to $500,000, we start paying into this as licensees through license fees, right? Once it reaches $1 million, we no longer pay into it, right? So what you're gonna see is because anytime they disperse from EDO, we have to pay interest, so you'll never have to pay those fees as long as people aren't getting suspended and dropping out of the business and not paying it back.
I actually had that on a question on a practice quiz.
Did you?
Yeah, what's the max?
Max for the real estate recovery fund?
Mm-hmm.
About $1 million for the actual holdings, but then you can get up to $50,000 per transaction, up to 3, right? You can get treble, right? You can get up to 3 transactions per associate. After that, you probably need to be out of the business. Most people have been in the business 20 years and never have one. So if you've had 3, you probably need to be gone. You probably need to go away. Let's see. That's pretty much it for chapter 3 or chapter 4. Sorry. Wow, that's pretty good. I didn't write a whole lot on the board. Trying to keep it small because we're talking about a lot of stuff. So, office inspections, disciplinary process, chapter 5. So, chapter 5 is really the end of the bulk, right? It's the end of the bulk of how you run a real estate office. We talked about what we need as far as furniture. We talked about what we need as signage. We need staffing. We need files. We need to know how to handle conflicting demands. All these other things, right? But then we didn't talk about what happens when we get inspected. What happens if we are accused of something? What happens if we need disciplinary process? How we deal with the recovery fund? We did talk a little bit about the real estate recovery fund. $500K to $1 million. We talked about that, right? So, first of all, why is the main reason that we have to change our address in the system when we are a real estate company? Because we could just go out there and be where we want to be, right?
Well, then if you mess up,
Right, if we mess up. So if they're looking for us or if they're sending us a letter, we have to be compliant, because if they send us a letter and we don't respond in time, then they know that we haven't gotten our mail, right? Now, of course, people like me that don't check their mail every 3 weeks, that's a problem too, right? Because I don't like to check my mail. But if I'm expecting something, I will. Now, what if they send you a letter and say, "Hey, I'm coming to audit you," and you didn't get it, and they show up and the door's locked and nobody's here? Well, you can get an administrative fine, right? Or you can get a citation for $500 for not changing your address, right? So just like your driver's license, right? A lot of people don't change their driver's license address within 10 days, but they get pulled over and they get in trouble, right? So do the right thing. The real estate commission can, first of all, what does the real estate commission do? There's 2 things that they do. First thing that they do is they foster education, right? Right? Well, that's not the first thing they do. The first thing they do is they protect the public, right? They're here to protect the public, and they're here to foster education. They're here to help us educate the public. So don't take a FREC audit as, "Oh my God, we're coming down to beat you up." It's an education process to make you better so that we're protecting the public in the ways we should be protecting the public. A lot of people think, "Oh, well, an audit's a bad thing." No, an audit's not necessarily a bad thing. An audit might tell you where your deficiencies are. Yeah, you might get a notice of non-compliance. You might get something. But if you didn't know, let's fix it and let's move on. Let's make sure we're protecting the public. So we need to have a sign. We need to maintain our branch offices. The first thing they're going to do is check the sign. They may ask you to provide a couple files, right, to review. Or are you getting the radon disclosure signed? Well, it's in the contract here, so we always have it signed, right? Are you getting lead-based paint signed for houses prior to 1978, built prior to 78, right? Are you getting coastal construction zone line disclosures signed when they're on the beach, for example, right? These are things. We are going to review the licenses. Are your licensees acting legally and their license are inactive? Or have they done their continuing education? All these things are important, right? Are you providing your brokerage relationship disclosures? Or are you functioning as a transaction broker and you don't need that, right? So those are things that matter, right? Are they going to audit your escrow account? Absolutely. They're going to check for your reconciliation. That's why if you have an escrow account, you need to be doing that. If you haven't used your escrow account, you don't have to reconcile it because it's never used. But if you use it, you have to reconcile it every month for the next 5 years. So either have one or don't have one. It's up to you, right?
So if you used it last year, or it's been 12 months, it doesn't matter, you have to reconcile it every year for the next 5 years. Oh, okay.
5 years. Okay, so then there's this whole complaint process. How does it work? It's kind of like a legal process, right? So, and I'm not going to go really in depth to it. Somebody files a complaint. Say that you're violating fair housing or whatever the case is. They file a complaint, and then this investigation of the complaint happens, right? On the back end, the licensee is not even notified at this point, right? Then they have this probable cause determination. There's a two-member probable cause panel, right? Steps in the complaint process. I'm gonna put that up here because it may be on the test. So they have this probable cause panel of 2 people, right? There's 7 members of FREC. We didn't cover that yet, but we'll cover it. There's 7 members of FREC. 2 of them are picked to do this probable cause, right? And then if there's probable cause found, we're then looked into further. They file this formal complaint. So there's an informal complaint that comes in, maybe it's anonymous or whatever. They find probable cause, they file a formal complaint. If they don't find probable cause, they close it out and they move on. And they say, haha, they did the right thing, right? And then once there's a formal complaint, you can have an informal or you can have a formal hearing. An informal hearing happens when somebody doesn't contest it, right? They say, no lo contendere, I'm done. I'm not going to contest this, right? Formal complaint, you're going to have a hearing in front of FREC. Once they do the formal hearing and you're found guilty or non-guilty, it doesn't matter. There's this final order that's issued, right? And this final order is issued, and then at the very end of it, there's a judicial review. Now, who does this final order? Do you remember?
Yeah, it wasn't. It was. It's always the court.
It's an administrative law judge,
Yeah.
right? And that's on page 136. It's administrative law judge. Once that's done, of course, everybody's notified through this process, right? The sales associate's notified, the broker's notified, everybody's notified, right? Once this final order is done, then the courts are gonna issue some type of penalty, right? Or, as most people would do, is they'd go and do some judicial appeal, right? They'd appeal this, a judicial review.
But FREC doesn't do criminal.
Correct. They do administrative.
Only admin laws, okay.
So you can get through this whole process and be cleared by the real estate commission, but you can still get sued criminally and civilly, right? So this is only one piece of it. Remember, FREC deals with licensure, right? FREC deals with that piece. They don't deal with criminal and civil law. If they found that you did something illegal criminally, they're going to refer that over to Department of Law Enforcement, right? That term, the Division of Administrative Hearings, it's going to employ people of the Florida Bar. That's who's going to handle the whole formal hearing process. The recommended order is the law judge, right? The recommended order. FREC is the final order, but the recommended order is the law judge. And if you need to get more information from somebody, what do? You subpoena it, right? That term subpoena, you already know what the subpoena means, so I don't need to go over that. Now, you can get a license denial when we're going all the way back to applying for a license. Why would they deny your license? Well, it could be something incomplete, right? Could be something that you didn't pay the fees, right? Which are, yeah, that's fine, we'll figure that out. Neglecting to correct errors, so if they gave you 30 days to correct errors, right, then you need to correct them in a timely manner because time is of the essence. Or if you fail to complete one of the examinations, right, all these things would get your license denied, right? So they have the right to call me up and say, hey, did you pass the exam, furnish the records, right? They could do that, right? So again, they can audit a real estate school the same as a real estate office, right? And come in and check all that stuff. We talked about revocation without prejudice, so we don't need to worry about that. We talked about different types of administrative penalties. We never covered letter of reprimand. So letter of reprimand is misconduct that has no disciplinary action. It's a letter of guidance. So this isn't it's not common, but if something happened and you didn't do something right and they say, hey, slap on a wrist, we'll get this done. Letter of reprimand, letter of guidance tells you, here's how you should practice in the future, right? We're not going to hold this against you. However, if you do it multiple times, it could go on to an escalated level, right? So it could be a notice of non-compliance, which you have 15 days to correct, something like a sign on your door, right? Citation, something $100 to $500 is something a little bit worse than a notice of non-compliance, but it's not really a threat to the public, right? Then you have probation, you have a fine, suspension and revocation, right? Fines could be up to $5,000, or I'm sorry, yeah, fines. Putting you on probation may say, I need you to complete another course, for example. I need you to repeat course 2 because you did something wrong, whatever the case is. Suspension means I could take your license for up to 10 years for whatever reasons, right? If it's something that's really bad. And then revocation is permanent. If you do fraud, if you run a Ponzi scheme, if you do all these other things that are financial crimes, they're going to revoke your license, you're never getting it back. They revoke one license, they're going to revoke them all, whether it's Florida, Alabama, Georgia, New England, wherever it is, right? So, moving to the next piece. Administrative fines are up to $5,000. We talked about that. Your penalties, the FFF and the 111. Don't worry about second degree misdemeanor. Unlicensed practice of real estate is a penalty, is a felony in the state of Florida, $5,000 fine, up to 5 years in prison. The real estate recovery fund, we talked about that a little bit. A couple things that we have to do. They have to file a civil lawsuit against you. They have to obtain a judgment. They have to try to take claim on a judgment. And if the licensee files bankruptcy, the commission can waive that final judgment requirement. There has to be an affidavit. There's a bunch of other things you have to do. The keys here is, if you're a member of that transaction, a real estate agent cannot take a claim on the real estate recovery fund if they're acting as a licensee at all. If they're acting as a consumer, they can, but if they're acting as a licensee, they can't, right? So, for example, if I'm a for sale by owner, and I'm only acting for the sale of the house, I'm selling it by owner, I'm not using my license or anything, then there's a situation that you might be able to claim on a real estate recovery fund if something were to go wrong, right? But if you're selling for somebody else, you can't, right? They can claim against you. Now, your spouse can't claim against you, because what if you're in a divorce situation, they don't like you, right? Maximum payments are $50,000 up to $150,000 if there's 3, right? We talked about those. The licensee fees are $1.50 for sales associates and $3.50 for broker associates, or brokers and brokers associates, if they had the need for that. We already talked about there's hardly ever a need for that. If you commit a crime, you have 30 days to what? You have 30 days to report it, right? And we're not talking about traffic violations. We're talking about major stuff, right? It didn't talk. Where is the fund reimbursement for? There is a mandatory suspension if you do have a claim paid.
147 is mandatory suspension.
I was trying to find the part about who can make a claim. You should remember, if you are party to that transaction, they can't claim against you unless you're acting as a licensee and solely as like if you're acting, you can't make a claim. Like real estate agents can't make a claim unless they are acting only as the consumer. So I guess here's an example. I buy a house, right? I buy a house as a consumer, and I'm working solely as a consumer. I'm not representing myself as an agent. I'm buying from a builder, right? There's a site agent that's representing the builder, and there's nobody representing me as an agent. I'm not getting commission or anything. That's when I can make a claim, right? If something were to go wrong. Chapter 5. That's part 1.